It's time for a Pulaski TV Today legal tip, brought to you by Pierchoski Law Firm. Here's Stan Pierchoski.
Hello, my name is Stan Pierchoski, and I'm here today to talk to you about last will and testament. Many people come in and ask me about writing a will for them, and most people would like to know the importance of having a will. So let's discuss that. Do you realize that less than 12% of the population deceases without a will? That's a very small number. But a will is important to have because with a will, you can express the wishes, your wishes after death, how you can pass your property on to your family, to your friends, or anybody specific. If you have any specific bequests to give to an individual, it can only be done through a last will and testament, such as if you have a prized shotgun you want to leave your son, you can do that. But it can't be done unless those wishes are expressly put down in a last will and testament. The effect of not having a will is that if you don't have one, the state of Tennessee will write one for you. That's done in probate during the administration of your estate. Your descendants will inherit your property, but it won't be according to your wishes. In other words, it will be what they call per stirpes, where all your descendants will get equal amounts. Sometimes when people decease in a will, they want to leave a certain amount of property to certain institutions or certain people. They can control the amount in the will. If you die intestate, then it's done per stirpes. Everybody gets an equal share, which may or may not be what you want. But the only way to control what you want is to deal with the will while you're still alive, or what we call intra vivos, have the will written and ready to go so that when you decease, your estate will have that to administer. The will is actually what we call a non-operative document. It does nothing until you pass away. In other words, if you have a will while you're still alive, you can change it, you can burn it, you can crinkle it up and throw it away. You can do whatever you want because it has no legal meaning while you're alive. Once you decease, it springs into life as an operative document and controls your wishes with your property. It leads me to my next topic. What about updating a will, or how often should you do that? Well, if you write a will and 20 years later your property is pretty much the same, there's no real need to make any changes. Now, when you change a will, you can either write a whole new one, or you can write a codicil, which is an amendment. Either way is just as formal as the other. Every will has what we call a residual clause. Residual clause basically says anything I did not mention in my will goes to, and then you designate where it goes, a charity or a person or whatever. If something changes in your life, like say you win the state lottery and suddenly come into $10 million and you don't change your will, well, guess what? That $10 million is not identified anywhere in the will, and it will pass under the residual clause to whoever you gave the residual to, which may or may not be what you want to have happen. If you want to control your wishes and your property after your death, the only way you can do that is with a formally executed, attested will. It's easy to do, they're relatively inexpensive, and I highly recommend it.
This Pulaski TV Today legal tip has been brought to you by Pierchoski Law Firm. If you need legal advice, contact the Pierchoski Law Firm at 931-363-7222.